Good morning, ladies and gentlemen. I call to order the 3,387th meeting of the Human Rights Committee. This morning, we'll start with giving the delegation the opportunity to answer yesterday's question, but then for 20 minutes. And after the 20 minutes, the members will give the floor to put up follow-up questions, and then immediately after the questions for the second round. I'll kindly ask the delegation to make good use of the 20 minutes and try to stick to the point, please. And with that, I'll give the distinguished head of delegation, Your Excellency, the floor. You have the floor.
Thank you very much. I would like to give the floor to Mrs. Shaisa Perez Malik to respond to previous answers.
Thank you very much. First of all, I would like to say Assalamu alaikum and a very good morning to all the members, to the chair, and to everybody. I wish we had more time because there were so many questions, and you know what we are working back home. As a political worker, I would have loved to share with you, but I will try to be as short and as precise as I can and try to satisfy the people who questioned. First of all, there was a question on jirgas. I would like to tell you that it's a traditional and cultural thing and which cannot be changed at once. But jirgas, it's a form of ADRs, which is alternate dispute resolution mechanism in petty civil matters. It's to be noted is that it's only in petty civil matters. However, they cannot exercise jurisdiction in criminal matters. Government is taking steps to regulate and supervise them under law. The sole authority of pronouncing binding judgment lies with the courts, and their execution is responsibility of the government and not of the jirgas. There are strict punishments even for jirga members who could involve in decision contrary to the law. Illegal jirgas which would make decisions in criminal matters. And I would like to hear quote that women leading a women jirga, Tabassum Adnan. It's a 25-member from Swat, and it is a jirga council installed that the women is heading that jirga. Tahira is a report has been mentioned in CEDAW report also. Numerous issues have been settled through her jirga, the women issues. The jirgas are more structured, and more people are going to criminal courts for redress. The penalties enhanced. The women complaint centers are providing free legal aid and help all the distressed women and victims. And here I would like to mention that the Aptabad case was quoted. The case is going. They are all behind bars, and law is going to take a legal action against it. So we are moving in the right direction. You know, as a Democrat, I'm proud of our participatory democracy, a democracy for all, especially for women. We are moving in the right direction, you know. People are more aware now. They are talking about issues which they never did before. So at least the awareness is there, and issues are being handled. There was another question on, my pronunciation on gag. This was another customary practice which was unjust and discriminatory. Provinces have taken various steps and measures to control harmful practices. And KPK, that is Khyber Pakhtunkhwa, where it was, This act was passed in 2013. It is effective. And it has been, it has been enforced. It is there. It exists. So there's nothing to worry on that also. And this was yesterday, I think I have tried to explain. And the discriminatory issues that were against women, a lot of steps have been taken that reserved seats, special seats, quota was there, but now it has been enhanced that every party would give 5% seats to women voters. And in constituencies where, as I mentioned yesterday, where the women voters will be less than 10%, the Election Commission can cancel it. A very good thing is that the disabled special people, they will be able to have their postal voting is allowed for them. And this has been passed by the cabinet, so it will be effective in this electioneering year. These were the, and the participation of, that I can come later on.
Yes, yes.
Okay. These were the few things I wanted to talk about. It was your question and I wanted to answer. Thank you very much.
Now I would like to give the floor to Mr. Shafiq.
Honorable Chair, I just wanted to reply to a follow-up comment of Honorable Member of the Committee on yesterday, that the Commission, I earlier said that Commission is totally working independent of the government interference and influence. My honourable colleague, Mr. Ishaq Masih, who is representing religious minorities in the Commission as well, he's sitting beside me. And while we are here, and yesterday I said that we are not aware of any such information that our chairman was not allowed to travel to here. And I would like to know about more detail about that source or credibility of information, that how it is come to the notice of the committee, because at the commission we are not aware of any situation. And then in that case we will be able to respond that what was the reason or what was the basically substance behind that information. Because the commission, as the commission decided that we should be participating in these reviews, we got facilitation from all the concerned stakeholders at the official level in Islamabad, and from Geneva, from the Office of High Commissioner for Human Rights, everywhere. Thank you.
Now I would like to give the floor to the Ambassador for Hamil. Okay. We have one member from minority community who is represent the NCHR, Mr. Ishaq Masih. I would like to give the floor to Mr. Ishaq Masih.
Mr. Saab, I'm grateful to committee for giving me opportunity to take part of this dialogue. I also want to share with this honorable committee that NCHR working totally independent and without influence and pressure of the government. Government is facilitated the commission for working. Thank you very much.
Now I would like to give the floor to the Ambassador for Hamil to respond the rest of the questions.
Thank you very much, sir. Yesterday there was a discussion and comments about the death penalty, but before I get to that point, I wanted to sort of highlight some of the comments that were made. Let me first say that it would be a grave injustice to the memory of 5-year-old Khola, a little schoolgirl who was murdered by terrorists in the APS. Now, as far as I know, that poor little girl did not know that she was an officer under training. So for the record of the committee, I would like to clarify that these were school children murdered by terrorists. Pakistan has faced the onslaught of terrorism like no other country, and we are facing this issue. Now, this was not a military academy, sir. Now, let me just get to the issue of the death penalty. This was a voluntary moratorium in 2008. This is the first thing we should remember. And Pakistan is a democratic country, and the government is answerable to the people. And whatever decision that the government takes is a consequence of democracy. And when there was a decision, this was taken after a national consensus. Please let me underline the importance of democracy in this. The people of Pakistan have voted for this. The people of Pakistan, through their parliamentarians, have voted for this. Now, having said that, the issue of death penalty, we could all be very passionate about it one way or another. It is an issue that has convulsed societies for millennia. We're all aware of that. Now, whether our personal likes and dislikes on the issue of death penalty it's a personal issue. But on a national issue, we have to listen to the will of the people as best expressed through the parliament. Now, let me just come back to the specifics. Pakistan pursues its policy on death penalty in line with its constitution and national laws in consonance with international norms. Our laws regarding the death penalty are not in violation of the ICCPR. The award of the death penalty in narcotics offences is not in contravention of Article 6(2) of the ICCPR. In fact, that article provides imposition of the death penalty in the most serious of crimes in accordance with the laws enforced. The interpretation of the most serious crimes may vary from country to country and local situations and religious particularities. In addition, the due process of law and fair trial standards are always invariably followed. Now, let me just come back to some specifics about this. My colleague from the Ministry of Human Rights has given me specific data. Since this death penalty was reimposed, 562 on death row, total executions 428, and the military courts of 53. So there has been a gradual, or let me also highlight, there's been a gradual decline in the executions from 2015 to 2017. And let me also point out to the esteemed members of the committee, the use of the death penalty is a criminal justice issue and is the right of every state to determine their own criminal justice systems. In any case, this is an ongoing subject, and I would say that our Law Review Commission and the Ministry of Human Rights is constantly reviewing it to narrow down the scope of the death penalty. Another important point to remember, we talked about the issue of the right to life. There was a national consensus. People in Pakistan spoke up. People through our democratic society, through our vibrant civil society, through our very strong media and independent media, people talked about this because we had a spate of horrific crimes directed at children. So when we talk about the right to life of the criminals, of the terrorists, there had been an utter disregard for the right to life of the victims. And we need to remember this, and it's not just applicable to my country, it is applicable to many other countries as well. Now, the other thing is that Pakistan does not, and I repeat, not execute minors. This has been repeatedly proven in the courts of law. And the last point I quickly want to make is every accused sentenced to death has the constitutional right and access to the institutional mechanism through the Ministry of Interior to file an application to get the pardon and reprieve and respite and to remit, suspend or commute any sentence passed by any court, tribunal or other authority. Every person who has been awarded the death sentence has the right to seek pardon or commutation of the sentence. Ladies and gentlemen, let me also highlight Article 45 of the Constitution of the Islamic Republic of Pakistan clearly stipulates, and let me read this, the President shall have the power to grant pardon, reprieve and respite, and to remit, suspend or commute any sentence passed by any court, tribunal or authority. I've repeated this twice because I wanted to stress that aspect of clemency. All the prisoners sentenced to death, whether by ordinary courts or by the military courts, are given the opportunity to seek a presidential pardon. This is part of the right to due process of law as guaranteed in Article 10A of the Constitution of Pakistan. We have a lot of statistics and details on this, but due to the paucity of time, we can share these in a written report afterwards, and I will pass on to you, if that's possible. Thank you.
Thank you very much. I'm addressing the issue of abortion that was brought up by Ms. Cleveland yesterday. I'd like to clarify, first of all, that previous to the law that we have today, the British law criminalized abortions. Now, the change in the abortion law, which took place in 1999, identified three things. One, it says very clearly, whoever causes a woman with child whose organs have not been formed. Under Islamic jurisprudence, Islamic scholars allege there should be between 120 days, 8 weeks or 12 weeks. So that's one point to note. Second of all, the issue is of the woman's health. It could be the change in law permits abortion between these 12 weeks, not only to save the life of the woman, but to provide a quote-unquote necessary treatment. Now, this has suddenly broadened the scope of the law. Not only now do you have to think about the age of the fetus, but you also look at the health of the mother, and the word necessary treatment is a very, very broad parameter. So it can be used, making it easier both for the woman and for the service provider. Furthermore, let me bring to the notice of this August House that never, to my knowledge, has anybody ever been convicted for abortion, either receiving or providing abortion. The issue of abortion is, there are many NGOs that are working for abortion. They have made great strides in providing health services to women, and their achievements highlight the fact that this is an issue that has not been in any way tampered with by the government or other agencies. Furthermore, I'd like to bring to the notice of the House that the Punjab has just recently developed what is known as the Service Delivery Standards and Guidelines for High Quality Safe Uterine Evacuation and Post-Abortion Care 2015, which provides guidelines which do not exclude induced abortion and cover all aspects of abortion. The issue of health and mortality is one of serious concern in Pakistan. We are far from the MGDs, but there has been considerable improvement. Just give you an example, from 2000 to today, maternal mortality has declined from 490 to 250 deaths per thousand, and 1,000 under 5 mortality rate from 138 to 85 deaths. This is far from the MGDs, but there is an improvement. Also, the allocations to the health sector have increased. Pakistan has one of the largest networks of lady health workers in the country. We have, I think, 120,000 women which provide tertiary, primary, and secondary care. And the budgets, though below what they can be or need to be, they are slowly increasing for the provision of health care. So this is just to address the issue of abortion that was brought up yesterday. Thank you.
Thank you very much. Now we are going to ask the members to post follow-up questions and immediately questions for the second round. The first on my list is Mr. Hines.
Very much, Madam Chair, and I would also like to welcome the esteemed delegation. Thank you very much for this opportunity to engage with you in constructive dialogue, and thank you very much for the answers given so far. I had the opportunity in a former capacity as Special Rapporteur to engage with the State Party on a number of issues concerning the right to life, and I welcome this opportunity to further engage in discussions on issues concerning various aspects of Article 6 of the Covenant. I want to recognize advances on issues such as the level of attention to honor killings, the 2016 legislative action that has been taken and progress that has been made on a number of other fronts, often dealing with difficult issues. The concerns I want to share with you, and I would very much appreciate your comments on those. Some have been raised by colleagues, but perhaps just to bring in a different angle. I think there's a general concern about extrajudicial executions by members of the police and the military, so-called encounter killings. Human rights groups have documented numerous reports in the Swat Valley, for example, in the Northwest Frontier Province, by the military, for example. And I think the general concern there is not just the fact that it happens, but in particular also the impunity that exists. As for journalists, some 73 deaths have been recorded since 2002. But the area that I want to focus on in particular is the death penalty that has been discussed to some extent. As has been mentioned, there's been a very significant increase after the resumption of the death penalty, failing the dreadful terrorist attack in Peshawar in 2014. The 6 years moratorium has been suspended, and that really meant that Pakistan went from a state that was not executing at all to being regarded as the 5th highest executing state in the world at the moment, behind China, Iran, Saudi Arabia, and Iraq, with some 7,000 people on death row estimated at the moment. The concern is not in the first place that the death penalty is used at all, but I think the concern is about the safeguards, the substantive and the procedural safeguards, and the extent to which they are complied with. The most important substantive safeguard, of course, most serious crimes, that requirement, which is an international standard and which is applicable to all states that are parties to the Covenant on Civil and Political Rights. And that has been interpreted by this committee and by others as referring to acts of intentional killing, of murder. The concern then is, if one looks at the number of people executed in Pakistan since the resumption, is that in some 20% or so of cases, it's estimated that terrorist activities that really involved intentional killing were involved. But in the other cases, that many of them do not comply with the standard of most serious crimes as internationally understood. In addition to that, there are the procedural safeguards, fair trial, and I think we'll deal separately with military courts. There are the issues of the high level of confessions, 95% or so of cases based on confessions, the secrecy, the fact that members of the executive preside in those cases, but also the secrecy concerning the other cases, even outside of the military realm, and the lack of knowledge of what transpires in those cases. The mentally ill, the execution of the mentally ill, the paragraph 8 of the response by the State Party to the issues raised by this committee says that no mentally ill prisoner has been executed. In contrast to that, is the case, for example, of Mr. Munir Hussain, who was diagnosed in 2014 with intense psychological illness to the extent that he couldn't recognize his family or remember anything of his earlier life, and then in spite of international protestations was executed in 2015. There's also the concern about the right to apply for clemency, which is in the Covenant in Article 6.4. And the concern there is that, and it has been mentioned, that yes, everybody has the right to do so, but there does not seem to be a single case where such clemency has been granted since the resumption of the death penalty. And the concern there is that in theory this right exists, but in practice there's a policy of not granting it at all, which then makes it really an empty right. So it would be very useful if we can be given even a single example of a case where such clemency was in fact granted. There's also the concern about execution of people under 18. And a case in which I was personally involved also, as far as interventions by the international community is concerned, was the case of Safkat Hussain, who was arrested in 2004 for murder at the time when he's believed to have been 14 years of age. And that's, of course, the important time, is the time alleged crime. In spite of international interventions, he was executed in 2015. And I think the concern there is that the assessment of age seems to be made largely simply on the basis of looking at the accused and then saying this person is 18 years or younger. Whereas the international standard is that the onus is on the state to prove that the person was indeed, to indeed prove the age of the person concerned and prove that the person was not under 18 at the time of the alleged crime. Medical examinations need to be done, and so any information on such medical examinations and on the approach of the state party in respect of establishing that this procedural safeguard is met will certainly be welcomed. So in conclusion, I don't think there's an expectation from the international community or from international law for overnight abolition of the death penalty. But it's subject to very stringent requirements, substantive requirements in terms of the sort of crimes for which it can be imposed, and then the procedural requirements. And then if I look at the reply of the state party, and it has been mentioned here as well, that the initial rationale for reintroducing the death penalty was terrorism. It seems to be used in some cases, or in many cases, where terrorism is not at stake. But even in the reply of the state party, it is said that the incidents of terrorism have decreased, and I think for that reason, the appeal is even if we do not go back to a complete moratorium, which of course would be the ideal, the appeal is to respect the safeguards as far as the substance and the procedure is concerned on the death penalty. I thank you very much and look forward to any responses.
Thank you, Mr. Hines. We are going to ask question on issue number 10 up to 13 plus issue number 3. And now Mr. De Vroegveld has the floor. Up to 19, just 10 to 19, and then 3 also. Mr. De Vroegveld, you have the floor.
Merci beaucoup.
Thank you very much, Madam Chairperson. And I'd like to thank the delegation for the answers given. Today, I'd like to address issue 3. Because yesterday, we took advantage of the Commissioner for Refugees to broach the issue of refugees. Issue 3 is to do with anti-discrimination provisions set out in national legislation. The state party puts forward Article 25 of the Pakistani Constitution and explains the provisions of Article 25. It says that it makes it possible to uphold Articles 2, 1, 3, and 26 of the Covenant. Now, if we look at all of the grounds for discrimination a little more closely that aren't included in the legislation in Articles 26 or paragraphs 2, 1 are not included in Article 25. However, the state party explains that the interpretation of Article 25 of the Constitution by national judges is in fact very broad, and it makes it possible to encompass all grounds for discrimination set out in Articles 2 and 26. So here really we have to ask ourselves whether it would be better to codify this jurisprudence into a piece of consolidated legislation on the fight against discrimination. And this was recommended very recently to Pakistan by the Committee on Economic, Social and Cultural Rights. It recommended the adoption of the overall legislation to combat discrimination. And this then would make it possible to codify this jurisprudence or case law of national courts. Now I have a question here. Could the delegation tell us whether there is any bill underway or whether you've thought about adopting consolidated legislation in the area of discrimination. And have you gathered together case law from national courts in order to take into account this broad interpretation of Article 25 as put forward by the state party? Now, one question arises here with respect to gender equality. Yesterday, I mentioned the reservations of the state party to the International Covenant on Civil and Political Rights, particularly the reservation to Article 3. And I understand that the delegation perhaps hasn't had time to reply to that question. Perhaps you could think about withdrawing the reservation or amending necessary legislation. And on the basis of gender equality, I'm reopening this question once again because the reservation to Article 3 basically refers to the personal status law from 1962 and the law on evidence. Now, does the state party intend to amend the provisions of the both pieces of legislation I mentioned in order to establish gender equality and to look at financial transactions and all of the discriminatory provisions that remain in the personal status law of 1962? Now, on the decriminalisation of homosexual relations between two consenting adults, and I'd like to ask about combating discrimination against persons on the basis of their sexual orientation or gender identity. Unless I'm mistaken, the state party doesn't really provide a reply to that question. It addresses a very sensitive issue, and I'd like to thank the delegation for broaching the issue of intersex persons. And the state party has told us about progress made in taking account of intersex persons and the situation there. I think that we need to welcome the developments and the progress made. However, you do not answer the question on decriminalisation of same-sex relations. Now, once again, the Committee on Economic, Social and Cultural Rights in paragraphs 21 and 22 recommended that decriminalisation take place. Does the state party intend to adopt legislation on the reform of same-sex relations, and what measures may in fact be adopted to combat discrimination based on sexual orientation or on gender identity, because these are also grounds for prohibited discrimination. Thank you very much, Madam Chair.
Thank you, Mr. De Fulfil. Now the floor is for Madam Cleveland. You have the floor.
Thank you, Madam Chair, and I would like to express my appreciation to the delegation for the responses, particularly with respect to Article 338 and abortion. I have a few follow-up questions, and then I will return to my issues for today. On voluntary termination of pregnancy, I very much appreciate the clarification. I'm pleased to know that the law is not as restrictive as the committee was under the impression. You've indicated that the concept of necessary treatment is broad. So on that point, I would like to ask, does it include treatment that is necessary for the mental health of the woman? You also say in paragraph 19 of your reply to the list of issues that Article 338 does not allow abortion in cases of incest, rape, or fatal fetal impairment, among others. Is that still correct? So in other words, are those not considered to be necessary treatments for the woman under Article 338? And again, I would like to ask, what legal instrument is the interpretation of Article 338 based upon? Is there a court decision or a regulation or someplace someone can go to find out what this article means? Because the definition seems to be frustratingly opaque. Okay, and in that regard, I would welcome information about what efforts you have taken to clarify to medical care providers and to the general public about the circumstances in which access to abortion is lawful in Pakistan. Is, for example, the legal standard for access to abortion taught in medical schools? And what efforts have you taken to ensure nationally that abortion is delivered safely by qualified providers? How are you ensuring this, in particular, given the apparent division of responsibility and primary responsibility of provinces such as Punjab for regulation in this area? And finally, what are you doing to combat stigma against women who seek an abortion? I had one follow-up issue on the death penalty also, which is that in addition to the international legal constraints on administration of the death penalty that have been addressed by my colleagues, the death penalty cannot be applied in a manner that constitutes torture or cruel, inhuman, or degrading treatment either to the convicted individual or their family. And in this regard, the committee is concerned that with the sudden return to administration of the death penalty and the very high number of executions that have occurred, 316 in the first year, I believe, that the protocols and procedures for administration of the death penalty by hanging are not being meticulously observed, that communication with family members is not occurring, that physical examinations of the individuals sentenced to death, height and weight measurements, test hangings are not occurring, that there's a shortage of executioners, and that ordinary prison staff have been carrying out executions, and resulting references to botched executions. So my question here is, what are you doing to ensure that the death penalty, if imposed, is imposed in a manner consistent with Article 7 of the Covenant? I'd now like to turn to the issues for today. My first issue is, well, my first two issues involve counterterrorism and the courts. Issue 10 involves the Protection of Pakistan Act and the anti-terrorism courts, and then issue 11 involves trials before the military courts. So with respect to the Protection of Pakistan Act, we express concerns regarding the breadth of authorities bestowed by this act. We understand that the act expired in 2016, but there were significant concerns regarding authorization of the use of force and arrests and searches without warrants by law enforcement, authorization of preventive detention for up to 90 days if ordered by the government, overbroad offenses, in-camera trial proceedings, and so forth. My question with respect to the Protection of Pakistan Act is there any plan or proposal in place to reenact the act in some form, and if so, what are the details of that plan or proposal? And would there be any effort made to reform the proposal to address the concerns I've raised? You stated in your reply that 30 individuals were tried by the special courts under this act. Can you give us information on the outcome of those cases, including information on acquittals, convictions, and any sentences imposed, including any removal citizenship? And what happened to any cases that were pending and persons who were detained under the Act after the Act expired? Were the cases transferred, and if so, where? And were they transferred to the anti-terrorism courts? Now, with respect to the anti-terrorism courts, the committee is very concerned about, in particular, the broad scope of jurisdiction under the Anti-Terrorism Act, as well as concerns regarding fair trial and due process protections, and the fact that juveniles are tried and sentenced as adults. It's my understanding that the definition of terrorism under the Act includes all crimes striking fear in the hearts of people, and that a broad range of cases have been understood to fall within this jurisdiction, including ordinary murder, kidnapping, and robbery, including a Supreme Court of Pakistan case that held that a single murder committed in public fell within the Act. So as a result, these courts appear to be overburdened with thousands of cases that ought to be in the ordinary courts. In December of 2016, reportedly, there were 3,360 cases pending, some of which had been pending for up to 8 years. So what are your plans to reform the anti-terrorism courts to ensure fair trial protections, and in particular to narrow the definition of terrorism to true terrorism cases and reduce the backlog? Turning to military courts, in issue 11, we understand that the jurisdiction of these courts has now been renewed and extended to 2019. And I would like to explain the concerns that we have regarding these courts so that you'll have an opportunity to correct any misunderstanding, which I would be grateful for. And then I will raise some specific questions. So you indicate that the military courts have jurisdiction over cases transferred from the anti-terrorism courts and also over persons detained under the Actions in Aid of Civil Power Regulation of 2011, which authorizes the armed forces in the FATA and PATA to detain suspects in secret indefinitely. We're concerned about reports of secret detention as a result, as well as ill treatment, reports that suspects are routinely detained incommunicado in secret locations, that 90 to 95% of convictions are based on coerced confessions, which raises serious questions regarding the use of torture and cruel, inhuman, or degrading treatment. With respect to due process concerns, the procedures of these tribunals are entirely secret. Defendants reportedly have no opportunity to choose their own counsel. The judges' identities are secret, but Amnesty reports that they are members of the chain of command without formal legal training. And information such as the charges, evidence, and reasons for convictions are not made public. Your written submissions to the committee indicate that there is a right to appeal in the civil courts in the form of the Supreme Court from judgments of the military courts. But it is my understanding that the scope of review that is actually available before the Supreme Court is extremely limited. In other words, the Supreme Court does not have ordinary appeal jurisdiction to review claims arising from the military court system, but can only exercise extraordinary review jurisdiction that is highly constrained. And the civilian courts accordingly have rejected challenges relating to conditions of detention, enforced disappearance, access to counsel, or coerced evidence. And then finally, with respect to the procedures, there have been a substantial number of convictions, including, I believe, as indicated this morning, 161 death sentences. And I would just like to note here that per se, the procedures of this court cannot be considered to be consistent with Article 14 and 15 of the Covenant for purposes of lawful imposition of the death penalty. Among those convicted are 5 persons believed to be victims of enforced disappearances. So as I said, I would welcome corrections regarding any of that information. My questions: what plans do you have to reform these procedures to address the various concerns regarding conditions of confinement and fair trial process? What criteria are applied to transfer cases from the anti-terrorism courts to military courts? With respect to coerced confessions, it's my understanding that in August of last year, the Supreme Court dismissed a challenge brought by families to the lawfulness of confessions in the military courts on the grounds that all the confessions stood proved because they were recorded by magistrates. Now, the International Commission of Jurists notes that this decision stands in stark contrast to the jurisprudence of the ordinary courts and the treatment of confessions in those courts, which are viewed with suspicion if obtained after long detention by the police. So, specifically with respect to confessions, does a different legal standard of review apply to the admissibility of coerced confessions in the military courts? You indicated that no juveniles have been arrested or tried before the military courts, but Amnesty International reports that one of the convicted persons was 14 when he was arrested. He had been missing for 6 years after his arrest, and his family heard about him for the first time 6 years later when the Army announced his conviction before the military courts. Can you please respond regarding this case? With respect to the right of appeal before the Supreme Court, how does your system afford meaningful right to appeal as required by Article 14 of the Covenant for all criminal cases, given the restrictive jurisdiction of the Supreme Court? And what other civilian judicial oversight exists for such claims? And what remedies are available to suspects? Finally, with respect to ill treatment, and this overlaps with the general issues relating to ill treatment in the list of issues. But in paragraph 39 of your reply, specifically with respect to this issue, you indicate that Pakistan investigates all complaints of allegations of torture and takes disciplinary action against those responsible. Given the secrecy of detention and of the legal proceedings in these courts, what mechanism do you have for receiving complaints of torture, ill treatment, and incommunicado detention for persons detained therein? How many complaints have you received? How many have you investigated, and what was the outcome? The Committee Against Torture also raised significant concerns regarding this issue. So what have you done to respond to those recommendations to secure accountability and prevent mistreatment in the future? Finally, my last issue for today involves freedom of movement. And here I had one follow-up question, and I apologize that the official responsible for refugees is no longer with us. But I had asked a question regarding restrictions on freedom of movement for refugees and asylum seekers. And I received a response regarding the numerous individuals who are not subject to restriction on freedom of movement, which I understand to include refugees who are not in camps and who have high-tech cards, identification cards. But my question is about those who are subject to restrictions on freedom of movement. Are there restrictions on freedom of movement on some refugees and asylum seekers, including potentially those in camps and those who do not have identification cards? With respect to the rest of this issue, Section 2 of the Exit from Pakistan Control Ordinance of 1981 states that the government may prohibit any person from traveling outside Pakistan, that there is no requirement for an advance showing of cause before such an order is issued, and that the grounds for imposing the order do not need to be disclosed. With respect to restrictions under this Act and others, can you first explain to the committee the differences between the exit control list, the blacklist, and the visa control list? What are the criteria for registering individuals on these lists and the processes for doing so? Do you always provide advance notice to individuals whose names are placed on the list? And what opportunity do individuals have to challenge being placed on the list? How many names are currently on the exit control list and the other lists? You mention a reform by which thousands of names were removed from the exit control and blacklist. What was the process for removing those names, and what steps are being taken to ensure that thousands of superfluous names are not placed on the lists or remain there in the future? There are reports that the exit control list has been used to prevent freedom of movement for unjustified or political reasons. These include reports that in March 2017, the Islamabad High Court directed that names of alleged blasphemers be put on the exit control list, that a Pakistani journalist, Cyril Al-Maida, was placed on the list in retaliation for an article that he wrote about tensions between the civilian government and the military, that former President Musharraf's name was placed on the list in 2014 and was upheld by the Supreme Court, although he eventually was allowed to travel to Dubai for medical treatment, and that activists from Baluchistan are routinely prevented from traveling abroad. Can you please comment on the measures that you take to ensure that the exit control list and other travel restrictions are not improperly imposed on journalists, persons charged with crimes, and other, or persons charged with blasphemy and activists? And can you comment on reports that the Frontier Corps and other security forces have blocked entries and exits in Baluchistan on various occasions in 2015 and 2017? My last question here involves restrictions on passports. What are the specific circumstances under which a passport may be canceled and the procedures therefore? We had asked for this information but did not receive it. And what areas currently are subject to restrictions for foreigners traveling within Pakistan? Thank you very much.
Thank you, Madam Cleveland. Madam Branskarish, you have the floor.
Thank you, Madam Chairperson. And I would like to also thank the delegation for the answers provided, and in particular on the issues in violence against women and the added information on the jirgas received today. I have a couple of follow-up questions. Nevertheless, I think on specific information I had requested, and I don't think I heard an answer. However, of course, if more convenient, certainly it could be provided in writing, as you suggested with others, since much of that dealt with the specific statistics and numbers, the complaints, investigations, prosecutions, and convictions, both in terms of the Punjab violence against women law, also on the situation and follow-up on the honor killings law, as well as the situation with the Sindh and Baluchistan domestic violence acts that are now already a couple years in place, but we did not get information on the number of cases that have been recorded and prosecuted under those acts, as well as for those, the latter ones, the measures to implement them that have been taken specifically, and whether there are any obstacles to actually implementing those acts. Further, there was the specific question on the bill on domestic at the national level that was mentioned in the report, but not clear where the bill stands presently. And finally, on the anti-rape bill, the questions on whether marital rape is included, and also if you could please address the issue on the implementing measures specifically that have been taken for that bill, in particular the special procedures that are apparently foreseen in the bill, and whether those have been applied to facilitate actually cases under that law. Now I turn to my questions for this session, which will be two issues, the issue 12 and issue 16. For issue 12, the committee has noted the state parties' replies to the list of issues with the information that Article 14.2 of the Constitution prohibits torture for purpose of extracting evidence, as well as all the information on the penal code prohibition for public servants to act in a way that would injure another person, and the other references you already have provided in the documents, including also the police order of 2002 that includes penalties for on police officers who torture or abuse a person in their custody. Nevertheless, the Constitution limits its prohibition to torture only for purposes of extracting evidence, and thus leaves out torture for other purposes, such as obtaining from him or a third person information or confession, punishing him for an act or he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind. This, of course, being the text of Article 1 in the Convention Against Torture. In fact, none of the provisions that you have reported provides a specific definition of torture that in full reflects the requirements under our Covenant's Article 7, as explained in General Comment 20, or indeed Article 1 of the CAT, which was also noted in the concluding observations of CAT for just June this year. So please provide additional information on steps taken, including amendments to legislation to codify such a comprehensive and specific definition. The question also relates to the penalties foreseen. We note the difference in the police order 2002 with a maximum imprisonment of 5 years. It is lower than what you report as the 10 years mentioned concerning public servants from the Penal Code article, although that specific article I think also you have not included, so I would appreciate the specific reference as well. We know that the obligations include ensuring that penalties are commensurate with the gravity of the crime. So could you please also indicate any steps for amendments, legal amendments, to ensure that this is the case? The replies to the list of issues indicate that torture, custodial death, and custodial rape prevention and punishment bill, which has been pending before the National Assembly since March 2015, is to be presented in the joint session of the Parliament, you report. Could you please provide the committee with updated information on whether the bill has now been adopted, and whether shortcomings in that bill, including concerns regarding the independence of the investigative body, have been addressed? Then finally, in addition to concerns already referred to by Madame Cleveland, I also wanted to note the state party's reply to the list of issues regarding the compatibility of Section 21H of the Anti-Terrorism Act of 1997, whereby confessions made under the custody of police or security forces in terrorism cases are admissible as evidence in court, and that compatibility with Article 7 of the Covenant. Nevertheless, the explanation you provide indicates that such confessions can be admitted by court section officers if made before a police officer not below the rank of superintendent of police, and that superintendent was present during the confession and, quote, had reason to believe that it was made voluntarily, end of quote. In contrast, the Article 38 of the Qanun Shahadat Order of 1984 ensures that confessions made in police custody are inadmissible in court unless they are made in the presence of a magistrate. Such a provision indicates the recognition of the need to build in safeguards against mistreatment and torture for the purposes of obtaining confessions. Could the distinguished delegation please inform us how the provisions under the Anti-Terrorism Act guarantee that accused under the Act are not tortured or ill-treated in order to obtain confessions, and why even the safeguards, albeit limited, in the Qanun Shahadat order are not deemed necessary in this law? Are amendments to this provision and added safeguards planned to ensure that coerced confessions are not admitted as evidence in courts? I turn now to my second issue for this session, which is issue 16 on bonded labor and human trafficking. The committee notes the information provided in the state party replies to the list of issues on significant administrative and legislative steps taken to address issues related to bonded labor in Pakistan at the national and more recently also at the provincial levels, with laws adopted in Punjab in 2012, as well as an ordinance on the prohibition of child labor at brick kilns in 2016, and as well as in KPK in 2015. And you also note that similar legislation is being drafted in Balochistan and Sindh. Nevertheless, reports indicate that bonded labor practices persist and are widespread, especially in the brick kiln industry and among Christians and Dalit. And the committee would appreciate additional information beyond what is contained in the State Party report and reply to list of issues on specific measures taken to implement the prohibitions in practice. Have workplace monitoring mechanisms be put into place that perform regular inspections? How effective are the district vigilance committees mentioned in the state party's replies, and where is the information on their work compiled and analyzed so that an overall picture of their work can be formed? Have specific steps been taken to address bonded labor in domestic work, including by children? Could you provide data on how many violations of these various laws have been identified, investigated, and prosecuted, and with what outcomes? Have victims received reparation? Have steps been taken to raise awareness on the issues and the legislation, including for relevant civil servants, law enforcement, and the judiciary, as well as the public at large? Furthermore, in response to the question regarding the Prevention and Control of Human Trafficking Ordinance from 2002, the State Party gave only a limited reply regarding capacity raising through training in the 36 districts of Punjab. So could you please provide the committee with data on the situation and its evolution, as well as specific information on steps taken and planned to ensure its implementation? Thank you very much.
Thank you, Madam Baramkarish. Mr. Iwasawa, you have the floor.
Thank you, Madam Chairperson. I thank the distinguished delegation of Pakistan for giving responses to our questions in the first part of our dialogue. I'm afraid, however, that the question that I asked with regard to enforced disappearances and extrajudicial killings remains largely unresponded. I would appreciate it if the distinguished delegation would provide us with additional information and responses to the issues raised with regard to enforced disappearances and extrajudicial killings. Now I turn to issues for this morning. I will ask questions on issues 13, 14, and 19. Madam Chairperson, please allow me to speak longer today than yesterday, because I have 3 issues today. I start with issue 13 on investigation of torture cases. In the written replies, the State Party explains that the Constitution and the Penal Code prohibit torture, and that torture has always been condemned by the State Party. However, we have received reports which indicate that torture is still widespread in the country, and it is alleged that serious acts of torture are used by security forces, military, and intelligence services as a systematic tool to obtain confessions. Could the distinguished delegation please explain what measures have been taken to effectively combat torture and ill treatment by law enforcement officials? In the list of issues, we requested information on the measures taken to put an end to the culture of impunity. In the written replies, the State Party replied, and I quote, "The allegations of prevalence of culture of impunity are misleading," end of quote. However, we have received reports that perpetrators of torture are granted practical immunity. Have there been any criminal proceedings opened against police officers suspected of committing torture? Could you please provide information on disciplinary sanctions and convictions imposed on the perpetrators of torture? I understand that under the Actions in Aid of Civil Power Regulation of 2011, as well as the Army Act of 2015, members of the military and paramilitary forces are granted retrospective immunity from prosecution for torture. What is the rationale for giving them immunity? According to information before us, there is not independent oversight of police conduct in the State Party. Could you please comment? In the written replies, the State Party explained that the Human Rights Cell in the Supreme Court and the National Commission on Human Rights can deal with human rights-related complaints. How effective are these mechanisms in investigating torture cases? Are there other mechanisms in the State Party which can carry out independent investigation of torture cases? I would like to ask about one specific case, the torture and death of a political activist called Aftab Ahmad while he was in the custody of the Rangers in May 2016. Has any Pakistani authority carried out an independent investigation into this case? In the report, the State Party stated that although there are no specific rules for payment of compensation, there have been instances of award of compensation by the courts, even against police functionaries, end of quote. Please provide more detailed information on compensation available to victims of torture and their families. In the list of issues toward the end of issue 13, we requested a variety of statistics. I'm afraid that we have not received these statistics. Could you submit the statistics in writing, maybe in writing after the dialogue? I now turn to issue 14 on pre-trial detention. According to information before us, unsentenced prisoners make up the majority of the prison population, 69% in 2015. And it is reported that individuals remain in pretrial detention even for periods longer than the maximum sentence for the crime. Could you please comment? What steps does the state party intend to take to reduce the length of pretrial detention? According to information before us, preventive detention in peacetime is allowed on a number of grounds, such as prejudicing the integrity, security, or defense of Pakistan, the external affairs of Pakistan, or public order. This power has been endorsed by the 2014 Protection of Pakistan Act, PPA, which allows security forces to conceal the location of detained persons and the handing over of these persons to security forces without legal oversight. It is reported that hundreds of people have been subjected to preventive detention under PPA. The UN Working Group on Enforced Disappearances expressed concern that PPA is not in conformity with international human standards. The written replies state that PPA is no longer in force. However, there are reports that the government is considering renewing PPA for another 2 years. Could the distinguished delegation please comment on the report? According to information before us under the 1997 Anti-Terrorism Act, security agencies are allowed to detain any person suspected of being involved in the activities of a proscribed organization for up to 1 year. Could you please comment? In the written replies, the state party stated that the constitutional remedy of habeas corpus is available under the Constitution. How many habeas corpus cases have been filed in order to obtain release from security-related detention and preventive detention? And in how many of those cases the courts had actually granted release? According to information before us, where the court orders the detainees released, the court has to rely upon the statements of security agencies to know whether the order has been complied with, because there's no independent mechanism to monitor the release. Could you please comment? In the report, the state party explained that the courts have granted compensation for illegal arrest and detention in appropriate cases. Could you please explain what cases the courts have granted compensation? According to information before us, the judge's discretion to grant compensation is rarely exercised. Could you please comment? In the list of issues, again, the committee requests statistics, and I'm afraid that we have not received all of the statistics. Could you please submit the requested statistics in writing, maybe in writing after the dialogue? I now turn to the last issue, issue number 19, on the justice system. In the written replies, the state party explained that the judicial reforms had been introduced through the National Judicial Policy of 2009. What are the results of the judicial reforms? And there are some issues in the issue number 19, so I would address some of the sub-issues. First, I address sub-issue 1A on the judicial appointments. The Special Rapporteur on the Independence of Judges has criticized the judicial appointments in Pakistan, especially in the High Court. She stated that nepotism had led to the appointment of persons of mediocre competence to the bench. Could you please respond to the criticism? What are the criteria for judicial appointments? I now turn to sub-issue B. According to information before us, the budget allocated to the judiciary is minimal and insufficient. In the written replies, the state party stated that efforts are underway to increase budgetary allocations for the judiciary. This is encouraging. Could you please explain in more detail the plan to increase budgetary allocations for the judiciary? And could you please respond also to the reports that the low level of judiciary lacks basic facilities such as electricity, separate offices, computers, and other equipment? What steps are taken to improve the working conditions of the judges? I now turn to sub-issue C, the shortage of judges, and E, the backlog of cases. The State Party explained that the filling process of vacancies in the judiciary is ongoing. Could you provide us with data that indicate improvement in the shortage of judges and the number of vacancies? I now turn to sub-issue D on the corruption in the judiciary. According to information before us, there is a general perception among the public that the judiciary is corrupt, especially at the level of the high courts and lower courts. What measures are taken to combat the corruption in the judiciary and to guarantee the independence of judicial institutions? I now turn to sub-issue G on the lack of protection mechanisms for legal professionals. We are concerned about reports that legal professionals, as well as victims and witnesses, face threats and attacks from various actors, including non-state actors such as extremist religious groups, insurgents, and terrorists. The written replies state that the need to provide protection to victims, witnesses, and legal professionals, including judges and lawyers, is under consideration by the Law Reforms Committee. Could you please update us as to the progress achieved in this regard? And could you please provide information on the number of persons who have been executed for threats and attacks against legal professionals? Thank you, Madam Chairperson.
Thank you, Mr. Iwasawa. Mr. Benishore, you have the floor.
Merci.
Thank you, Madam Chairperson. I will be addressing issues 15 and 18, but before I do so, I would like to ask a follow-up question on the death penalty. On the death penalty, then, the moratorium was lifted in December 2014. The report and the delegation have explained to us that this is a national consensus. It is the exercise of democracy, the will of the people, and so on. I'd like to make two comments in this regard. My first comment is that the entire human rights system consists of avoiding potential breakdowns in the democratic system, because the democratic system is the least bad of all systems. But there might be dangerous effects on human rights, an impact on human rights, and the history of the modern world is full of experiences showing that democracy can lead to results which are counter to human rights. I won't list examples, but I would say that in the world today there are many dictators, and I'm from a country which has experienced dictatorship. I know what I'm talking about. And dictators often speak in the name of democracy and say that they are supported by their people. That's not the case of Pakistan. I'm not saying that that's your case at all. But what I'm saying is that the democratic system may have flaws. The democratic system cannot lead to results which are counter to human rights and which are contrary to the covenant, because it contravenes the entire human rights philosophy. So that's just my first comment on national consensus, according to which the moratorium has been lifted. It was lifted in 2014. My second comment to that end is the following. You tell us that this is based on national consensus, but we have received information saying that this is rather a unilateral decision taken by the government. I'd like to ask a question. I'm not affirming anything, but I'd like to know whether this decision has been contested. Some NGOs, and in fact I have just consulted, I've just been looking at the press, the written press, recent press, which has criticised this reintroduction of the death penalty, stating that this was a unilateral decision taken by the government and that it's not the result of any democratic decision. So my question would be to the delegation would be whether they can clarify that point for us. So these are my follow-up questions on the death penalty. And just one further remark, if I may. You spoke about pardons. I've read the Pakistani constitution, which has extremely interesting points, and there's a great deal of teaching in it. There's a great deal for us to learn. Yes, pardon does exist, but has that ever been implemented in practice? Can you cite a case for us where presidential pardon has in fact been accorded? So that wraps up my follow-up questions. I'd now like to turn to issue 15 on the list of issues and then to 18 subsequently. Issue 15 pertains to the measures taken to improve detention conditions in prisons, in particular healthcare, nutrition, hygiene conditions, and recourse appeal procedures in terms of ill treatment given overcrowding in prisons. I've closely read the responses of the State Party, particularly paragraphs 48 to 51. And I'll summarize them very briefly. You say on the legal, therefore, prison regulation means that prisoners must be treated in humane conditions, and this exists in the prison rules. A directive was issued to the Punjab prison authorities along those same lines. Articles 776 to 809 of the Pakistan prison rules mandate the prisons department to facilitate and provide medical cover to all inmates. So this is the delegation's initial response. You then tell us that new prisons are to be built, which will reduce overcrowding. And there's a third element which I would mention here, that is the setting up of these jail committees. And that's a very good measure which has been taken. It's a monitoring committee to monitor the detention conditions. And lastly, you tell us that inspection conditions have also improved. My comment then is the following. I've just very briefly taken you through the State Party's responses, but I'd like to say the following. Currently in Pakistan, unless I'm mistaken, there are 97 prisons. Their capacity should be around 42,670 prisoners. So 97 prisons, and official capacity should be limited to 42,670 prisoners, inmates. Now, currently, in the existing prisons in Pakistan, there are 78,000 prisoners. I'll make no comment. you can just see from that the prison population is far exceeding the prison capacity. I'd also like to point out that according to some information which we have received from non-governmental organizations, there are cases of torture in prisons in Pakistan which have been flagged. Not only in prisons for the convicted, but also in police custody premises. Some of my colleagues have already raised these issues, so I won't go into greater detail to avoid repetition, and I'll move to issue number 18, with your permission, Madam Chair. Issue 18 is a complex one. It pertains to the implementation across Pakistan of state laws and rules in federally administered tribal areas. But the real issue here is how can Article 8 of the Constitution be applied? How can it be implemented? This article guarantees fundamental rights of men, women, and children. How can Article 8 be implemented, and how can its implementation be guaranteed? Because any laws which are contrary to human rights must be considered as non-valid, invalid. How can this be then applied in the case of conflict between the provisions of the Constitution and Islamic law? And in particular in the sphere of human rights. The response given by the State Party to that issue is the following. For the FATAs, the FATAs, we won't go into greater detail. You tell us that there has been reform. Could you tell us where that reform is? What's currently the state of play with that reform? I won't insist on it. I would like, however, to insist on the relationship between the Constitution, human rights protection in a democratic system, as Pakistan is, and the application of Islamic law. And what happens in the case of conflict between these systems. We know that Article 2 of the Constitution of Pakistan states that Islam is the state religious religion of the state, and therefore no law may be promulgated if it is contrary to Islamic law. It's clearly stated in your constitution, and indeed that is the very nature of the Constitution of Pakistan. Exercised in full sovereignty. In the Constitution, it states that the Supreme Court shall ensure the implementation of that principle, that no law can contravene Islamic law. Now, this issue is much broader, to my mind, than what I shall just take you through now. The problem is much broader. And let me explain what I mean by that. In its preamble, the Constitution of Pakistan recognizes both the sovereignty of God over creation and over creatures, and at the same time it recognizes man's will to set up the political order, to establish the political order. The problem, I shan't quote the Constitution, I shan't quote the preamble in order to reduce my speaking time, but I do have them before me on the sovereignty of God, on the democratic system and so on. But the problem, to my mind, consists of the fact that if we are really to reconcile the two principles, God's sovereignty and the sovereignty of man, in establishing the legal order and political order, this is where the real issue arises. And this issue arises particularly in the human rights sphere. Because, on the one hand, we have a religious Sharia system which comprises certain norms. I know the system very well, and I know that it covers a number of norms and rules which are not in conformity with recognized human rights enshrined in the covenant. Several rules aren't in conformity, for example, the rules pertaining to criminal law, the application of the hudud, the family law, relations between men and women. In constitutional terms as well, when a number of Islamic states they state that the head of state can only be Muslim, is that fully respecting the equality of all citizens, whatever their religion, before the law and before the constitution? Consequently, when we affirm that no state law may contravene the rules of Islamic Sharia law, we might consider that in itself to be an affirmation, a statement which is contrary to the covenant. And it can be shown in practice. Pakistan, in its constitution, particularly Article 25, which is a very important article for us, Article 25 of the Constitution, recognizes, or rather prohibits all discrimination, any discrimination, and it's clearly stated in Article 25A of the Constitution of Pakistan. It prohibits discrimination based on sex. This is clearly stated in 25A. Now, my question is as follows. The rules regarding the family, the status of the family, the status of women, rules which exist in Pakistani law, which draws on Islamic Sharia law, are they then in accordance with this principle of equality which is enshrined in the Constitution? Let us take the polygamy, which was prohibited in some Muslim states. Tunisia, for example, is a Muslim state, and it has prohibited polygamy. The rules on polygamy, then, the rules on inequality for inheritance, the rules on witnesses, we're looking at a system where if two women need to bear witness for it to be the equivalent of the witness statement of a man. The rules on blasphemy as well. These rules, which are truly in accordance with the principle of non-discrimination enshrined in Article 25, and in particular the prohibition of discrimination based on gender. So this is what I'd like to ask of the delegation then. I'd like the delegation to take into account what I've just said. You remember that yesterday I spoke of Mohammed Akbel, and I personally consider that person to be the true founder of Pakistan, because, as I said yesterday, is the founder of the thinking, the reflection, and the philosophy behind Pakistan. And Mohammed Akbel said that the Quran is not a legal code. Earlier, I heard a member of the delegation say that abortion, according to Islamic law, could be authorized between the 8th and 12th week. But what Islamic law? In which part of the Quran do we find such a law? Therefore, Mohammed Akbel was right. He said to us that Sharia is, in fact, the work of men, the work of history, and not the word of God. And if the Quran is not a legal code, and if the rules emanating from it, for example, those inspiring family law and gender relations, if these are counter to human rights, is this not the place and time to proceed to an overhaul, a review of law in Pakistan? I think there's a problem here, a general problem, essentially, given for the legal and political system in Pakistan. And I do think that instead of drawing on the formal rules in Islamic Sharia, which are rules created by men, we might draw inspiration from the words of Muhammad Iqbal, namely, interpret based on ijtihad first of all, and then on the one hand, and then not to forget that legal rules evolve over time with changing circumstances, and that if there are very rare, very strange legal rules in the Quran, they need to be adapted to the changing times. And this is what a lot of Muslim countries have done, and I do think that Pakistan could make that effort and do the same, because it was one of the first countries to bring about the Islam of light, of liberty and of tolerance, and not the Islam of formal law.
And I would like to add another comment which I believe to be very important as part of this dialogue between the committee members and the delegation. At the end of the day, Pakistan is like many Muslim countries. In the Muslim world, we are the victims of a fundamental contradiction, which I will put to you. On the one hand, we experience terrorism, religious fundamentalism, jihadism, and Pakistan is one of the first victims of this terrorism and fundamentalism and radical Islam, etc. But on the other hand, by interpreting Islam in its formal dimension, in the dimension, unequal dimensions, well, by doing that, we are encouraging somewhat religious fundamentalism. This needs to be avoided. On the one hand, we suffer from this radical fundamentalism and the restrictive interpretations of Islam, the formalist interpretations of Islam. Well, that's on the one hand. And on the other hand, we are laying the ground. We are sowing the seeds, if you will, for all of this to be developed and strengthened. We need to strengthen instruments that will then in turn strengthen legal instruments. So these are the comments I wanted to make, Madam Chair, on issue 18. And I would like to ask the delegation to react to what I have said. We have questions 21 and others, but I think that we said that we would restrict ourselves to those and we would deal with 19 and 20 for this afternoon. Thank you, Madam.
Mr. Benashur, well, I turn to the delegation. I think you can get 10 to 15 minutes for a break to organize yourself. And I'll see you within 15 minutes. Okay. Thank you. Thank you. Ladies and gentlemen, we will resume the meeting, and the floor is for the delegation. Your Excellency, you have the floor.
Thank you. Thank you, ma'am. Pakistan is a multi-religious, multicultural society where people of different ethnic and religious backgrounds are living together. The Ministry of Religious Affairs and Interfaith Harmony has made constant effort to encourage tolerance and mutual respect through seminars, conferences, and consultative meetings of different communities in Pakistan. In Pakistani society, people belonging to various ethnic and religious backgrounds enjoy equal rights under Article 20, Article 21, Article 22, 26, and 27 of the Constitution. Minorities are free to profess their religion and visit their places of worship. There is no organized intolerance towards religious minorities in Pakistan. Celebration of 11th August as Minorities Day, also festivals of various religions are officially celebrated in Pakistan, in which political leaders, including Prime Minister and President of Pakistan, participate. These festivals include Christmas and Easter for Christians, Holi and Diwali for Hindus, Baisakhi and birthday of Guru Nanak for Sikhs, Eid-e-Ridwan for Bhais, Festival of Lights for Buddhist community, and Chelam for Khalsa people. 5% job quotas for minorities in all federal services, sumo motu action by Supreme Court in case of violation of rights of minorities. Interfaith harmony committees have been established by the provincial governments, which are playing a positive role to create healthy environment amongst different communities. The new Ministry of Religious Affairs and Interfaith Harmony works for harmony in society. It is formulating the National Interfaith Harmony Policy. On July 2014, the terms of reference of the National Commission for Minorities, NCM, were revised to make it more effective. I belong to a Christian community, and we are in minority in Pakistan due to less number of Christian faith people. But our Muslim brothers, they are in majority because the large numbers they have. But otherwise, are equal citizens of, we are equal citizens of, according to the Constitution of Pakistan, and the Constitution provides equal rights to each and every citizen of Pakistan without any kind of discrimination. We have 10 reserved seats for minorities in National Assembly, 4 in the Senate, and 23 in the provincial assemblies for ensuring political participation for minority communities. We have a representation of different minority communities in our parliament. We have Christians parliamentarians, we have Sikh parliamentarians, we have Hindus and Parsi parliamentarians who are sitting in the parliament, and they have a right to raise their voice for the uplifting and development of minority communities. I would like to share about myself as well. Being a Christian citizen, I served for my community and my country and my nation as a member of Provincial Assembly and as a Minister of Finance in Punjab province. My government had given me this opportunity to announce the annual budget on the floor of the House as a first Christian finance minister. Then government has chosen me and given me this opportunity to serve as a Federal Minister for Ports and Shipping, and now I'm serving as a Federal Minister for Human Rights. We are contributing to the development of Pakistan because Pakistan is our country and we are well-wishers of Pakistan, our country. May God long live Pakistan. Being a minority community, we have a constitutional right to go to our religious places for worship. We are free to visit place of worship, and the government providing us development funds to minority communities to build and renovate their holy places. If we compare Pakistan as a Muslim state with other Muslim states, then we will find that only Pakistan is a country who providing the development funds every year to the minorities of Pakistan. They can arrange their holy festivals at any public place with the help of local administrations as well. Finally, what a discrimination. I am heading this delegation that speaks itself as our democracy is strengthening and our anti-discrimination law will get stronger, not just through national legislation, but through public awareness, implementation, and training. Thank you. Now I would like to give the floor to the Ambassador, Mr. Farooq Amil, to respond.
Thank you, sir. I'd just like to first be able to respond to some of the follow-up questions, and in particular comments that came in on the death penalty again. Firstly, the esteemed committee members have given us almost a barrage of questions, which are very pertinent. We understand that. But to give that justice, obviously you don't want a glib one-liner. It's not a quiz show where we just press a button and it's 10-second response. You need to have a proper reply from our authorities when we can go back and examine what you have had to say in light of the reality on the ground. So this is the first point that I wanted to make, and we would be grateful if once the committee accepts that we will be responding in detail to all these questions in writing subsequently. Now, of course, these are serious issues. We can't just give a one-liner. As I said, there are serious misconceptions. And of course, we're talking about also things that have been raised this morning. We're talking about deep philosophical debates. Now, I didn't realize, and I don't think the delegation was under the impression that we were here to review the Holy Quran, which in our opinion is completely unquestionable. And I would like to reiterate that point. Secondly, if you do need to have this debate between the constitutional law and Islamic law, then you really need to have the people who are conversant in Islamic jurisprudence here to be able to debate this. And do you really think that we would be able to have a comprehensive reply to all these questions, which would, in our opinion, would take over a month? And you need to have those academics here to debate this. And so this is one thing that we wanted to reiterate. The other point was the delegation is here. Why? Because Pakistan, the government of Pakistan, takes this process extremely seriously, and we respect each and every member of this committee. And in that respect, we would like to engage with you. And as you see, we have a full delegation led by our honourable minister and from the parliament and from our federal ministries. And also the members of the National Commission of Human Rights are also here. So the questions, for example, one of the committee members asked at least 37 questions. I noted them down one by one. Now, how do we respond in 10 minutes to 37 questions that will do justice to, for example, Ms. Cleveland's very, very specific and very pertinent questions? It's impossible to do that in 10 minutes, or even an hour, or even, so we need to respond in detail. But what I will do is that we have many things here that I would like to share with the committee. Firstly, we were talking about enforced disappearances. In order to take effective measures to deal with the issue of enforced disappearances, in April 2010, the federal government set up a commission of inquiry on enforced disappearances under the Pakistan Commission of Inquiry Act 1956. This commission has actively investigated cases of enforced disappearances. As a result of this initiative, a number of the cases have been disposed of. The Commission has been vested with broad powers, including the power to register an FIR against whom evidence of involvement in the disappearance of a person is found. The Commission also has powers to order production of a person in respect of whom. it is suspected by the Commission to be held in illegal detention by some law enforcement or intelligence agency. The Commission receives cases from the Human Rights Cell of the Supreme Court, and I reiterate, Pakistan is a democracy of the Supreme Court of Pakistan, the civil society organizations, the National Crisis Management Cell of the Ministry of Interior, and directly from the families of the disappeared persons. On the direction of the Supreme Court of Pakistan or on its own, the Commission can file a first incident report in the concerned police station in cases of missing persons. The Home Secretary of the respective province is directed to constitute a joint investigation team, having representatives, and this is very important, from the law enforcement agencies as well as the intelligence agencies. The hearings in each case are held by the Commission in all over Pakistan, in Islamabad, in Lahore, in Karachi, and in Quetta, with the view to facilitate the families, and please remember this is about families of the alleged disappeared persons. The Commission is headed by a retired judge of the Supreme Court and has two members, a former judge, for example, a former judge of the Sindh High Court and a retired Inspector General of Police, very, very senior officials. Necessary financial resources under a separate head, also very important to note this, from the Ministry of Finance, and a staff are being provided to this commission. A sub-office has been established, which is working in Karachi since October 2014. It has been provided adequate resources by the relevant government ministries. The commission, with the resources provided to it, also hears for parallel hearings in Islamabad, Lahore, and Karachi. And before I move on to this other written part of it, I wanted to go back this morning to I mentioned this little girl, Khola, 5-year-old. She's a victim of terrorism, murdered by terrorists. There seems to be, in the view, not of myself, but in the view of the voters, we are a democracy, and the people of Pakistan have elected a government that, and I want to dispel this misgiving, that it was just an arbitrary decision. No, it wasn't. There was an all-parties conference. Every single political party in the democratic forum of the country arrived at a consensual solution and a resolve to deal with it. So this was not an arbitrary decision, and Pakistan is a democratic country. Pakistan is very much committed to the rule of law, and most of all, Pakistan has to listen to the voice of the people, and that is through our parliament. So I think it's very important to highlight this aspect, because if there is more concern for the perpetrators of the crimes, of course, they have to be duly, the proceedings, they must have the legal recourse. But this complete focus and disregard for the victims of terrorism, that 5-year-old girl, Khola, please think about it. She doesn't even appear in many, there's no discussion about this little girl. And she was at that school, and there are thousands or hundreds of children like this that have been brutally murdered, and that is the people's response that has come through our democratic institution, the parliament. So this is extremely important to highlight this. Now, coming back to the families of the disappeared persons, of course the state is worried about people who have disappeared, but you also have to remember that instances, and I don't have to stay on my continent of Asia, we can go everywhere else around the world, people suddenly go dark and they disappear. And now many major democracies around the world are scrambling to find where did they all go. Have they gone and joined a terrorist outfit? Where have they gone? The families are worried. The state is looking for them. How do we deal with this? So the state knows about this, and we have limited resources. Remember, we're a developing country of 200 million people, but we have the infrastructure of the legal jurisprudence to look at this. We have a national parliament, but we also have provincial governments, and they're also equally empowered to be looking and to be asking questions. It's extremely important. And if the family is worried and the authorities are unaware, how do you deal with a person who has deliberately gone dark and disappeared if they don't want to be found? And then we have an added problem in some parts of our country, which is proven. It's also there on the television. It's also there in the media, with a very important media that exists, that has exposed foreign interference in parts of our country, where some of the people there's state-sponsored terrorism that is taking place. Furthermore, in addition to that, I can think of a number of incidents where we've, when we were talking about the freedom of movement, we've had situations whereby people have unwittingly gone into areas that security operations are underway. Now, how do you retrieve those holidaymakers or tourists or people who didn't know where they should have really have gone, where they should not have been going, and they didn't put themselves in harm's way. They've put our security forces who have to mount rescue operations afterwards to retrieve these people. And I can think of certainly several years ago, there was one UN official that had gone there. And our security forces went there, and there was a loss of life of our security agencies. To find that person who had gone into this particular area, had wandered there, it was a UN official. So there are people that you have to take these realities into account when you're reaching your conclusion, and I'm sure the esteemed members of the committee would certainly understand that. Now, coming back to in Pakistan, all citizens are free to express their opinion and views, and I think because we have a strong parliament, we have a vibrant civil society, and we have very, very strong and independent media. We have over 100 television stations that are talking non-stop. It's good. It's very important for the media to be powerful and to be visible and to be speaking. No case of reprisal, harassment or intimidation concerning the families of the allegedly disappeared persons or human rights defenders or lawyers has been reported to the police, any court, or to the commission or any state authority by any individual or civil society organization. The government remains committed to take action on any case brought before a competent authority of the state. The relatives, the family members of the allegedly disappeared persons are regularly called to attend the hearings held of their cases in the Commission. They are also held in person by the President of the Commission in confidence, I will repeat that, in confidence of his chamber. In addition, the relatives of the disappeared persons as well as civil society organizations engage during these hearings. Families of the missing persons can file formal complaints not only in the police stations but also with this commission. Even before receiving reports of complaints by the family of a missing person, the Human Rights Cell of the Supreme Court of Pakistan or from any human rights organization, this commission has at several occasions constituted joint investigation teams without any formal complaint. This mechanism has been put in place to ensure accountability. By way of compensation on the recommendations of this commission, a monthly subsistence allowance is paid by Pakistan Baitul Mal in the deserving cases. Families of allegedly disappeared persons are also provided financial assistance through various social safety nets. The existing constitutional and legal framework provides for sufficient safeguards for the protection of victims and witnesses in general. To further strengthen the protection of the witnesses, especially women, standard operating procedures, I repeat, SOPs, have been put into place by this commission. After recording the statement of the witness, a direction in writing is issued that he or she should not be arrested. The commission has not received any complaint of harassment of any witnesses after these directives were issued. Now, furthermore, just moving on, the government pursues action against the perpetrators who have been involved in enforced disappearances. The Commission has been receiving possible cooperation from all the stakeholders, including the federal and provincial government departments, intelligence and law enforcement agencies. Consequently, the Commission has been able to dispose of 2,416 cases from March 2011 to 30th of November 2016. Out of which 1,798 persons have been traced, either returned to home, as I was saying earlier on about people going dark and then suddenly reappearing to their families, or confined in jails, internment, rehabilitation centres, or on criminal and terrorism charges. And the remaining 618 cases were closed either due to non-prosecution or after thorough investigation were found not being cases of enforced disappearances. However, it has also been noticed that at times there is a lack of sufficient incriminating material or concrete evidence to fix responsibility. It has been observed that sometimes inflated figures of enforced disappearances are quoted. And let me just add here that there is no authentic, there's no one number, there is no one authentic source that has been ever agreed on this. But these are the statistics that are reported to our concerned authorities. Appropriate mechanisms are in place to hold accountable anyone involved in the violation of human rights, including enforced disappearances. And by way of compensation, on the recommendations of the Commission, as I said earlier, the monthly subsistence allowance is paid. In terms of a little bit more about Balochistan, and one of the committee members had raised this. March 2011, 47 cases of alleged enforced disappearances pertaining to Balochistan were transferred to the Ministry of Interior. 237 cases were received by the Commission, and the total number of cases from the province of Balochistan is 284, out of which 180 cases have been disposed of by this Commission up till 30th of June 2017, and the remaining 104 cases remain under investigation. These are very complex cases, and of course it's impossible to have instant justice or instant resolution. These things take time, and our government authorities are very much resolved to dealing with them in that spirit. Now, as I said, this commission had been on inquiry on enforced disappearances. This was set up a few years ago, and let me get on to the counterterrorism aspects of what we were talking about. Pakistan's counterterrorism, and I'll go back once again. One of the committee members, esteemed committee members, had said something, and I quote, "ought not to be in an ordinary court." Now, what does that mean? It's a judgmental observation. It's surely the courts themselves can decide rather than be dictated to from outside. We certainly appreciate the participation and our engagement with this engagement here with in this meeting with the committee is extremely important. But these are opinions. Ought to be in an ordinary court, and I'll leave it at that. Pakistan's counterterrorism efforts are in compliance with its national and international human rights obligations. Pakistan has been confronted with the challenge of terrorism, and I will keep talking about terrorism because we have lost thousands of lives of little boys and little girls, grandmothers, children. Everyone has been affected. It's not just the security agencies, and they are humans too. Please don't forget that. So the terrorists have killed all these innocent people and depriving them of their fundamental right to life. We have no discussion on this. Perhaps we need to focus on that. The government is committed to combating terrorism in accordance with the National Action Plan Action Plan. Due to the efforts of the government, the terrorist incidents, yes, have indeed declined. But I will also point out that between where's that figure gone? I want to be specifically correct about that figure. There was a figure. Just give me 1 second. Yes, here we go. I don't want to mention the friendly government, but a very important friendly government in the West had, according to them, their ministry's official figures, they were from 2014, the period that we're talking about, and since the voluntary moratorium was removed, and following the all-party conference that democratically allowed the reinstatement of the death penalty in extreme cases. There was this friendly government, their foreign ministry said that there were 1,009 terrorist attacks in 2015 compared to the 1,823. That's a 45% increase. So this is also a reality that I hope that the esteemed committee members would take into account. Now, coming back to the Protection of the Pakistan Act in 2014, this did not give extraordinary powers to the law enforcement agencies. Rather, it aimed at providing speedy justice to the family of the victims of terrorism. Remember, the parliamentarians, our elected government, is under pressure from their constituents. Do something, and that is, I think, that's a global cry. Every citizen in every country is demanding of the government that they have to do something. So what our government is doing something and answering their democratic duty and the democratic call of the people of Pakistan. And that is why the Protection of Pakistan Act must be seen in that context. And, of course, it also provided protection to the judges and witnesses. The fact that only 30 individuals have been tried under the PPA demonstrates that it had only been used in extraordinary circumstances against terrorists who have committed the most heinous of crimes and have been carrying out terrorist activities. Now, the issue we were talking about, there were questions on the military courts. So, in accordance with the 21st and 23rd constitutional amendment, the military courts have been authorized to conduct trials of persons involved in offences relating to terrorism, waging war against Pakistan, and the prevention of acts threatening the security of Pakistan by any terrorist or terrorist group, armed group, wing, or militia, or their member using the name of religion or a sect. And I may again reiterate the involvement of foreign agencies in activities. It's there in the media. It's there for everyone to see. I don't have to elaborate on the specifics. It's there. It's a huge national discussion in my country, in our region as well. So please, you have to look at what we're doing in response in the specific and very difficult circumstances. We have had a surge of, we talked about refugees yesterday, and the number of people that have come across since 1947. We've talked about this. Pakistan, if you look at the statistics of Pakistan, if you have 5 million people over 38 years, that's 190 million people. You have to look at that. Is a huge, huge amount. We're a developing country with our own development challenges. And then when you look at this, what our government is honestly and sincerely through the Democratic Forum is trying to do, you have to look at it in that context. Therefore, coming back to this, any person who falls within the Pakistan Army Act, 1952, and the Pakistan Air Force Act of 1953, and the Pakistan Navy Ordinance, his trial has to be conducted by the military courts. The judges of the military courts have been well qualified to be a judge of any court. However, due to ensure their security, their names, qualification, and rank has been kept confidential. Why? Because of their security. They're under threat. Pakistan is committed to fulfill fair trial standards in accordance with our constitution and our human rights obligation, which have grown out of, and I keep repeating this, grown out of our democratic government, grown out of the will of the people. Whilst the proceedings of the military courts have not been made public, it has been ensured that all convicted persons have a right to appeal. And I mentioned this earlier on. They can appeal to the Supreme Court, which can review the judgments of the military courts. Besides, the military courts have not, and I repeat, not tried any juvenile, nor awarded a death sentence to any juvenile. So, all the cases that are to be tried in the military courts are to be approved by the respective Provincial Apex Committee of Law. Also, the sanction of the federal government for trial of such cases in the military courts is also a prerequisite as per law. The Supreme Court, in its judgment of 5th August 2015, has also provided for judicial review on the grounds of coram non judice in any order passed or decision taken or sentence awarded in such trials. The condemned prisoners by the military court can appeal to the Court of Appeals against any judgment passed by the military courts. They can also appeal before the Chief of the Army Staff. And they have the right to appeal for mercy to the President, as we've said this earlier on, under the Article 45 of the Constitution. The Pakistan Army Act, the amendment, 2017, renewed the military courts. The accused before the military courts will be provided grounds for arrest within 24 hours of arrest. He or she will have the right to engage a counsel of his choice at the trial. In case the accused is unable to engage the counsel due to any reason, the authority at its discretion may provide a counsel at the request of the accused and, please note, at state expense. The provisions of law of evidence shall apply at the trial. To provide legal oversight to ensure fair trial and due process in the courts, it has been laid down that no person shall be prosecuted under this arrangement without the prior sanction of the federal government. Furthermore, an appeal against the judgment of the military court can be filed before the Supreme Court of Pakistan under Article 185 of the Constitution. A convict of the military court should also have the right to pardon from the President. I keep repeating this over Article 45. It's very, very important for us. The above provisions show that the accused before the military courts have the right to a fair trial, as guaranteed in Article 10A of the Constitution. Now, as a state party to the Convention on Torture, and we've been through this the session here a couple of months ago, Pakistan remains committed to prevent torture or the ill treatment committed by the state functionaries. Whenever complaints have been received of allegations of torture, they have been duly investigated by the competent authorities and disciplinary action has been taken against those responsible. Now, the Pakistan Penal Code, I'd just like to highlight this, prohibits a public servant, because there was a question about this, from knowingly disobeying the law and acting in a way that would injure another person. The Penal Code also prohibits wrongfully confining someone or injuring someone in order to extort a confession. Anyone found using torture to extort a confession can be imprisoned. This is the law in Pakistan for 10 years. The CRPC requires police to conduct house searches in the presence of 2 or more witnesses. The police order of 2002 imposes penalties, including fines or imprisonment up to 5 years on police officers who torture or abuse a person in their custody. This order also provides a safeguard to the prisoners and detainees in the police custody. It ensures that any police officer, regardless of any rank, is liable for punishment if he inflicts torture. The Torture, Custodial Death and Custodial Rape Prevention and Punishment Bill is currently being considered by the Parliament of Pakistan and would be adopted once it's gone through the deliberations. So you have to see, esteemed committee members, the intent and the spirit of the government of Pakistan through this democratic order is very, very clear. And women cannot be imprisoned overnight as well during an inquiry. But because we are with our societal conservative norms, we are very cognizant of these of issues such as this. So a woman cannot be kept overnight during an inquiry of an FIR. Now, Section 21H of the Anti-Terrorism Act of 1997 is compatible with the Article 7 of the Covenant, which states that the conditional admissibility of the confession or any other law for the time being in force where there is court proceedings held under this Act, the evidence, which includes circumstantial and other evidence produced, raises the presumption that there is reasonable probability that the accused has committed the offence. Any confession made by the accused during the investigation without being compelled before a police officer, not below the rank of a superintendent of the police, may be admissible in evidence against him if the court section officer deems fit, provided that the superintendent of police, before the recording of such confession, had explained to the person making it that he is not bound to make a confession, and that if he or she does so, it may be used as evidence against him, and no superintendent of police has ever recorded such a confession unless, upon questioning the person making it, the superintendent of police has reason to believe that it was made voluntarily, and that when he recorded the confession, he made a memorandum at the foot of such a record. The allegations of prevalence of the culture of impunity. This is really this is a very serious matter. This culture, these are allegations, are misleading. The government has neither succumbed to any type of pressure nor tried to protect state functionaries. There are many cases where the judiciary has awarded punishment to those state officials who violated their service disciplines, and we will be sharing those details in our written detailed reply. As I said, we had hundreds of questions, and it's very difficult for us to respond so statistically, and we want to be absolutely correct in our replies. Moreover, the relevant departmental disciplinary committees have taken actions if any government official is found guilty of any unlawful action. Now, coming to the Human Rights Cell of the Supreme Court itself. The Supreme Court is the Supreme Court. It's a pillar of our democracy. To provide an expeditious and inexpensive remedy in matters relating to the infringement of fundamental rights enshrined in Chapter 2 of the Constitution, a human rights cell was established by the Supreme Court. You're all aware of this. The cell, and I would repeat, it functions under the direct supervision of the Chief Justice of Pakistan. It is mandated to expeditiously process the complaints and grievances received from the general public. Reports and comments are called for from the concerned quarters under the orders of the Chief Justice of Pakistan and disposed of. The cases requiring hearing are fixed in court and are decided there. relief, as I said earlier on, is provided to particularly to the poor persons, people without the financial means, without going through the traditional protracted litigation process. So this is, you see, the whole system is geared to help the people who would not have the money, the finance, and the wherewithal to follow this very complicated process, you see. So the system has an inbuilt mechanism so that it addresses the vast majority, everybody in Pakistan, not just the rich. In addition to this, the National Commission on Human Rights, the provincial government of Sindh have established, and remember we're a federal country with a federal parliament and very strong provincial parliaments, and so the provincial government of Sindh established the Sindh Human Rights Commission. And all provinces have human rights departments which are mandated to deal with the human rights complaints. I think I would leave the Ministry of Human Rights to my colleague and that particular issue. As I had said earlier on we've covered the freedom of movement, and there was one question from, if I may, with the permission of the chair. There was a. What was it? I had a. Yes, there was a question about the legal assistance provided to Pakistanis being sentenced to death abroad, and we hadn't answered that. We can give you look, there's a fact sheet with all kinds of figures of who's where. We do keep a track of our citizens. It's extremely important for Pakistan. Each and every one of the citizens of Pakistan matter to the government, and particularly those who are living abroad because they are subject to foreign laws. So our policy regarding Pakistanis awarded with the death penalty, and I'll just try to summarize this here, we immediately provide consular access. Because our embassies and our consular officials are, we have standing instructions that they must visit the citizen who has been detained abroad, and particularly for this death penalty. Arrangements are made to provide not just consular access, but to provide legal assistance if the person cannot afford it. This is very, very important. Most of the people, maybe they're laborers or somebody who doesn't have the money to fight an expensive court case. So the government has taken measures to provide legal assistance. The government has also, please remember this, there's allocated a specific fund, the Pakistani Community Welfare Fund, for this purpose. And for deserving cases, the government of Pakistan, and when I say deserving, people who have absolutely no money at all, they file requests for amnesty, and what we try to do is request the foreign governments for a pardon. And at the same time, but we have to respect the national procedures of the countries concerned. So, of course, when offences are being committed in foreign countries, we have an elaborate process. It does take place. We do look after our citizens, and particularly the people who have been awarded the death sentence. And I think I've just about covered a number of things on here, and if with the chairperson, Minister Saab's permission, I could pass this over to my colleague. Thank you.
Thank you very much. Just to elaborate a little bit on the issue of torture by the police, you may recall that Pakistan inherited the Police Act 1861, which was a very coercive law. The idea of colonial structure was to use the police to actually collect land revenue. So the culture within the police itself was a very coercive, in a history of domination and fear. Now the Police Act 2002 set up systems within the Act which provided opportunity, including a penalty of 5 years imprisonment for the misuse of power. Just want to give you briefly, because the Honourable Ambassador has given you a whole list of it. We have, under Section 44, what is known as a District Public Safety and Police Complaints Cell, which is at the grassroots level to address issues. There are issues of misuse, and the government is trying to find mechanisms for redress for the people of the country. At the provincial level, you have a provincial public safety and police complaints mechanism, in which you have a member of parliament, a National Assembly, as well as 2 women. At the federal level, you again have a federal police complaint authority, exactly on the same mechanism. And then we have a national police, public safety and police commission, which is chaired by the Honorable Minister for Interior. So you have these mechanisms within the Act itself. Further bodies which are responsible to address issues of misuse of power and torture are criminal justice coordination committees that have been set up under the district sessions judge. They comprise the SP of police of the area, the superintendent of the jail, somebody from the Bar Association, and parole officers. There is a Citizens Police Liaison Committee, which creates a bridge between the government and the civil society. And then you have 2 very active standing committees, both to the Senate and the National Assembly, to deal with issues of any human rights violations. Last week, there were some issues of human rights violations. I have a list over here of the number of incidents of abuse by the police, which I could share because there are a whole lot of names. In Punjab, I'll just give an example, about 200 constables, head constables, assistant constables. I have the number and I have all the details should anybody need them. In the Khyber Pakhtunkhwa, again, the same thing. In Sindh, we have a list of details also on some of the cases. These people have been incarcerated. They've been arrested and charged. I think some of the concerns were that the police people were simply transferred or demoted, but that's not the case. Criminal proceedings are pending against them. So that's one thing. I will leave this with you. In terms of compensation paid for abuse of power, again, we have a list of people who have received the compensation. The role of the health department is to confirm whether such torture ever took place. And the Ministry of Human Rights itself has a revolving fund to address and to give people of victims of torture. Recently, the government of Punjab passed the Punjab Civilian Victims of Terrorism Relief and Rehabilitation Act, which provides for compensation to torture through terrorism. We also have a list. I have this list, and I'll share it with you, of torture given in 2016 and in 2017 for the misuse of power by law enforcement agencies. So then I think now would we pass it over to the Honourable. Thank you.
I would like to give the floor to Mrs. Shaista Pervez Malik, Member of National Assembly.
Thank you very much. First of all, there was a barrage of questions which came up, and I will try to answer as many as I can if the time permits. First of all, we were talking about discrimination. Discrimination, you know, we at the government level and at all levels have realized that women are the soul of every nation. But, you know, combating discrimination is always a constant work in progress. As a democracy, we find elections on our manifestos and what we are there for to finish discriminations. We are elected or not elected. Then we pursue legislation, debate the opposition, and then vote and arrive at laws. There are no instant mix policies in a democracy anywhere in the world, I think. And combating discrimination must be seen in this light. I mean, do not doubt our resolve and do not doubt our courts. Indigenously arrived at solutions through democracy are the sustainable and transparent ones. The Constitution of Pakistan already discourages discrimination under various articles and establishes quite comprehensive anti-discriminatory regime, much stronger than most of the countries. Several provisions in the preamble, a separate chapter on fundamental rights, and another chapter on principles of policy all underline the principles of equal rights and equal treatment to all citizens, persons, without any distinction. The preamble of the Constitution not only aims at outlining the basic objectives of the Islamic Republic of Pakistan and the protection of all factions of society, but also attempts to define the minority subjects of Pakistan. It says, I quote, "Wherein adequate provision shall be made for the minorities to freely profess and practice their religion and develop their cultures," as mentioned by the Honourable Minister. Any and almost all the protections provided for in Pakistan's constitution, in fact, are guaranteed to all the minority races, women living in the country, and any race minority group can benefit from the same. Article 3 calls upon the state to ensure elimination of all forms of exploitation. Article 4 provides for the right of individuals to enjoy the protection of law and to be treated in accordance with law. This applies to the citizens as well as to, I quote, "to every other person for the time being within Pakistan." This article also clearly states that certain rights cannot be suspended. Under Article 8, any existing law or practice consistent with or in derogation of the fundamental rights shall be void. It further prohibits the state from enacting any law or policy in conflict with fundamental rights except any law relating to members of the armed forces or of the police charged with maintenance of public order for the purpose of ensuring the proper discharge of their duties. Article 25 ensures equality before law and equal protection of law. Article 26 provides for equal access to public places with an exception that these are not intended for religious purposes only. It further clarifies that no distinction as to the right of entry to such places shall be made on the basis of race, religion, caste, sex, residence, or place of birth. Article 27 provides for equality of employment in the public and private sectors. Article 11 and 37G prohibit trafficking in human beings as well as prostitution. Article 32 makes special provisions for the representation of women in local government, which is now, they are included in the local governments. Article 33 directs the state to discourage parochial, tribal, racial, and provincial prejudices. And for this, these were the articles I wanted to mention. And for this, the government's Decent Work Country program includes a strategy and a plan of action to promote the creation of decent work with gender equality as a cross-cutting theme. Similarly, the Labour Protection Policy 2006 acknowledges gender equality and the absence of discrimination against women and men as basic human rights that require protection. Benazir Income Support Program, that is another innovative scheme which provides cash grants to female heads of poor households, resulting in women economic empowerment. And for this, their bank accounts have been opened, and their NIC cards have been issued to give them financial independence. Then a good program is that Prime Minister's interest-free loans, of which 50% has to go to women. And that, besides empowering women through education, where, we don't have schools for girl child, schools are being built, stipends are given to the families to send their girls to school, because it is only through education and financial independence that we can empower our women. And reforms will pave way for more participation of women. So a lot of work is done on Achha, okay. My colleague wants to add some more.
I just want to add on to what the honourable member of parliament said. To eliminate discrimination and to increase the participation of women, quotas have been increased. In the National Assembly, 17%, the Provincial Assembly, 33%, in public sector jobs, 15%, in the civil services exam, 10%, in boards and vocational training, 33%, in microfinances schemes have been issued to women, and there's been a further entry of women into the labour force from 11% to up to 16% this year. So just to complement this. Thank you. Sorry, Shaisa ko bolne de, I thought you'd finished.
Now I would like to give the floor to Ambassador as well.
Thank you once again. Just two quick points, because I know the committee members are interested in statistics, and I do have some statistics which I wanted to sort of share with you. One was about, in the context of freedom of movement, we do have the next exit control list, and I think all countries do in some form or other. But the federal government has deleted, and I would say, deleted 4,987 names from the ECL, and only those persons who have been retained on the ECL whose period of placement is less than 3 years or who are involved in anti-state activities, terrorism, or related to proscribed organizations. In addition to the above 59,603 persons placed on the blacklist have been removed as per the following details. So I have a whole sheet of statistics which we can share very happily in our written replies. And what we're talking about is, in future, following the parameters shall be followed for the placement of the ECL on the recommendations, and again the judicial recourse to the Supreme Court, the High Courts, the tribunals having equivalent status, Defence Headquarters, intelligence agencies, the National Accountability Bureau, FIA, and the federal government. And I can list the people that have been placed on the ECL: espionage, subversion, acts of terrorism. Of course, this is conspiracy against the state, and of course, an act prejudicial to the integrity, security, or defense of Pakistan. I want to highlight these are not just arbitrary decisions that someone decides, well, someone has to go on the ECL. This is very much part of a written out, spelt out structure. Drug trafficking, human trafficking, money laundering, and persons belonging to the proscribed organizations, a deserter from the defense of or security force or strategic organization, and a lot of the people on ECL, economic crimes involving public funds and institutional fraud. This is extremely important for our country. Tax and loan defaulters or other state liability of more than 50 million, or fraud in a public corporate entity, an office holder such as a director. The placement on the ECL should be regulated as per this following policy guidelines. In case where investigation is underway, the period of placement shall be 1 year, which shall be subject to review by a committee in the Ministry of Interior or the recommendations of the relevant department or agency. In other cases, the placement placed on the ECL shall be 3 years, excluding terrorism, espionage, subversion, anti-state, narcotics, human trafficking cases. The review mechanism and appeal will be as follows. Any person aggrieved by an order of the federal government may prefer representation within 15 days to the federal government for a review of the order, setting out in the representation the grounds on which he or she seeks the review. The federal government shall decide the representation made within 60 days. A quarterly review would be undertaken by a committee within the Ministry of Interior in consultation with the referring authorities for fresh decisions in cases where the period of placement on the ECL is about to expire. So this review will be made by a committee of the Ministry of Interior of senior officers from different departments. One of the points I just wanted to add was it was for the delegation quite surprising to hear comments challenging democracy. For us, the democratic society and the democratic government of Pakistan To question that is, we found that a little odd, but we were very surprised to hear it. But we feel, and our government continues to stress the centrality of democracy in addressing all the solutions that are here before the committee. There is certainly no other way. We're not going to have arbitrary, authoritarian decisions, whether it's the death penalty, whether it's on the status of women. These issues cannot be addressed. They can only be addressed indigenously and through the Parliament and by the Parliament. Thank you.
We have just 2 minutes left, so I would like to give the floor again to Mrs. Shaisa Pervez Malik.
No, it doesn't matter. I just wanted, there was another question that marital violence or rape, that for us that comes, it's included in the domestic violence and seen in the same context. So if you want the details, we will go back. NCSW has done a lot of work on data collection. We would go back and get all the data collected and we'll send you in writing so that it's clear and transparent and you have the true. So I think so far this is all I have to say.
Thank you.
Thank you very much. Well, we have only 2 minutes, and I don't think that members will be able to ask follow-up questions now. So we will take a break now, and then after the break, the members will ask follow-up questions and questions for the last round. And with that, I wish you a happy lunch. Thank you.